from the Supreme Court this afternoon. Chief Justice, or suspended Chief Justice, if you like, Gertrude Tokonum, is the leader of the judiciary. Lawyers bow to her, but today she stood and bowed before a panel of her equals as she made a last-minute ditch effort to stop the ongoing constitutional process to remove her from office. The Chief Justice wants the entire process stopped and the judges on the special committee removed, but her case has been dismissed unanimously. Now, a member of our legal affairs desk, Kwaku Asante, was in court and monitored proceedings for us, and he joins me in the studio. Kwaku, first, you're welcome back.
Yeah.
So let's start with, there were a matter that was first dealt with, the supplementary affidavits. First, walk us through.
So even before that, the Deputy Attorney General, Dr. Justice Shremsai, who represented his boss in court today, wanted the court to strike out the names of Justice Poaman, Justice Asiedu Adibu, Dom Levo, and the two other members of the committee from the writ. And if you look at the face of the writ, the Attorney General is the first defendant, and the 5 members of the Article 146 committee are the other members of the committee. And so according to the state, this case can be prosecuted without having to attach those persons in it.
Right.
But then Godfrey Dame disagreed with that and said that they were seeking for certain reliefs that were directed specifically at those people. And that is why they had attached them as defendants in the matter. The court found favor in the argument made by Godfrey Dame and then dismissed the objection of the Deputy Attorney General and said the names of these 5 members of the committee must stay on the writ. Then came the matter of the supplementary affidavits. And Elton, in the last few days, we have been talking about that supplementary affidavit filed by the Chief Justice herself,
right,
which talks about what she believes to be degrading treatment of her, including going to the committee and being body searched, and her phones being taken, family members not being allowed, the judges proceeding, the committee proceeding to hear the matters, despite the pendency of her injunction application and all that.
And yesterday, for example, the lawyer who is representing her, Godfrey Dame, on Top Story said that she was actually searched by a mail.
A mail. And so these were all the arguments that had been deposed to in the affidavit by the suspended Chief Justice herself, and it formed part of a case requesting the Supreme Court to injunct the entire process. And so that is the case that the Attorney General made, that Article 146 contains that the entire process must be held in camera.
Right.
And there must be confidentiality. And that the Chief Justice, having deposed to affidavits and putting them before the court, and which court documents are public documents, is the Chief Justice's way of using the back door to publicize the arguments that will be made at a committee that must be in camera.
Right.
And so that is the argument he made and urged on the court to strike out the entirety of the affidavits that have been sworn to by the suspended Chief Justice.
Because what? The court was blind to whatever is happening.
Exactly. His argument is that the entire process must be confidential and no one else must know about it until it ends. And if persons are minded to so challenge the process in court, then they may do so. But Godfrey Dame argued that matters having to do with even searches and all that do not constitute part of the proceedings of the Article 146 committee. But it appears some members of the committee are taking of the Supreme Court had taken the view that they actually form part of the committee's work. And so Godfrey Dame pivoted with the argument a little bit and said, even if it were so, is it the argument that because this matter has the committee's work has to be in confidentiality, does it mean that if something goes on there that infringes on someone's right as a person and a constitutional right, they cannot go to the court to vindicate those rights? But ultimately, after the arguments were made, the court took about 5 minutes break to deliberate on the arguments that have been made by both Godfrey Dame and then the Deputy Attorney General. And then it came out with another unanimous verdict that the entirety of the affidavits that have been sworn to by the Chief Justice ought to be struck out of the records of the court as far as this matter was concerned, because it breached the confidentiality and the in-camera principle inherent in the Article 146 proceeding.
But does that suggest that when it comes to the matter before the 5-member committee, the Supreme Court has no business, interfering with it? Is that what it means?
It would appear that is the suggestion of the Supreme Court. And by 12 June, when their full reason ruling comes out, we will see what arguments they advance to back that point they've made. But it would appear now that the point that has been made is that so long as the Article 146 committee's work has not been concluded, you cannot use any proceedings thereof as a basis to file any action in court. But before 12 June, we'll get to see the judgment of the Supreme Court and get to see the arguments advanced on that. And then came the time for the substantive argument.
The injunction application.
The injunction application.
And I want to be, I want us to clarify this. So this injunction application that was before the court, this is different from another suit that is demanding that the entire process be telecast live.
Yes, and in fact, the action that this process must be telecast is the main suit that the Chief Justice had filed.
Right.
And then on top of the main suit, she had filed for an injunction application.
Saying that you should determine this before any other matter can happen.
Before we get into some of those matters. And the basis for this injunction application is that Godfrey Dame on his feet argued, just as we've seen in the court documents, that Justice Gabriel Scott Poorman, who is the chairman of the Article 146 committee set up by the president, actually in a ruling or in a certain judgment of the court, ruled in favor of one Daniel Ofori, who is one of the petitioners who is currently before the court.
And the matter between him and the Ecobank.
And the Ecobank. And then there's a matter of the police officer who said the Chief Justice degraded him and ordered his arrest. And in fact, in his petition, he says he will call Justice Poorman as a witness in that matter. The
same Poorman who is the chair of this committee.
And so for which reason, he says, then there is apparent bias in that matter, for which reason this is not a person that should be chairing that committee. That is for Justice Poorman. And then the court argued that there were a lot of questions from the bench that Justice Poorman in those cases was simply doing his work as a judicial officer, as a judge. And that if he ruled for Daniel Ofori, he did so on the merits of the case. And then the Chief Justice said, even he, Acting Chief Justice Bafuboni said, asked Dame that even he who is on the panel, there have been cases involving Daniel Ofori that he has sat on it, together with Justice Omoru Tanko, who was on his left. Does that mean they are not even qualified to sit on this matter? And then the Chief Justice said, even the lawyer for the Chief Justice said, even Justice Kulendi is said to be one of the persons that Ofori will even call as a witness and all that in the petitions that have been filed. And so that have to do with Justice Poorman. Then there was Justice Asidu Adibu. You recall that before the Chief Justice was suspended, she had put together a panel to hear Vincent Asafua's case. And Justice Adibu Asidu was part of the panel to hear that matter. To
determine whether the president should be injuncted from proceeding in the absence of the CJ having
been informed of the petitions and all that. But the president appointed Adibu Asidu as a member of the panel, of the 5-member committee that's going to look into the matter. And the view of the Chief Justice and his lawyers were that infringed on judicial impartiality, because it would appear the president, knowing that the judge was on the court, decided to take him out and all that. And then the questions from the judges was that, would that mean that when judges, will judges be precluded from hearing some of these matters when, for instance, if you're hearing a matter? In fact, Bafuboni's point was that there are judges who will be hearing a matter and they will be promoted to the appeal court or the Supreme Court. That has impinged on judicial independence. They think they thought not. And so they disagreed on some of those things in their line of questioning. Justice Sai then came in to make a point about, apart from the fact that he thought that the entirety of the argument was misconceived by Godfrey Dame and the Chief Justice, he made the argument that there's a high bar to be met for an injunction application to be granted against the performance of a constitutional duty.
Right.
And so if there's a constitutional duty that's being performed, you must prove beyond reasonable doubt that, one, your case is likely going to succeed at the end of the day, or you will suffer irreparable damage if the case is supposed to go ahead. And he does not think that a case has been made for some of those things, and the Welfare Kwaku case and all that. He actually cited the recent Supreme Court decision in the Vincent Asafua case to buttress his point. There were a lot of questioning from the bench to the bar, the judges to the lawyers, and then ultimately they decided to take about 5 minutes break. They take about 10, 15, or even 20 minutes. Then they came in and then said they had considered their application, and then by a unanimous decision, they had dismissed the injunction application. So all 5 judges, Justice Acting Chief Justice Paul Bafuboni, Justice Johnny Kulendi, Justice Omoru Tanko, Justice Richard J. Frimpong, and Justice Henry Kofi ruled that the Chief Justice's case had no legs to stand on with regards to the injunction application. and they dismissed it. All throughout, the Chief Justice sat.
Yeah, I just want to understand her mood in court today. This will be the first time she personally went to court.
Yes, the last time the matter came up and the Chief Justice was involved, the husband represented her in court. Today, she also arrived in the company of the husband, Mr. Tokunu, the former Yoko boss. They didn't use the main entrance to the Supreme Court. They used the other side, and then they came to use the same staircase as all of us. That's how we were able to record them as they were going up there. He sat there quiet through the proceedings. In fact, when he came in first, he sat to the left of the court, behind Justice Saim Cole, and then later on moved to the other side where Godfrey Dame and his legal team were seated. Most part of the hearing, he had a clenched fist, and he had just leaned to the left, and then with a clenched fist, for viewers, he had done something like this, and he was monitoring proceedings throughout, just quiet. Every now and then, she would put on a very faint smile. She would talk to the husband for brief periods, and then focus on the proceedings. In fact, at some point, I think something may have been said that startled her. She called a lawyer and passed some information to be given to the lead lawyers who were arguing the case and all that. But she was generally very calm in demeanor, very quiet through proceedings. In fact, at some point when the court did take a recess to consider their judgment, her right leg just on her laps, quiet, talking to some junior lawyers who were right in front of her and her husband, were having kind of conversations until the case was recalled and the judgment handed down. As soon as it was handed down, she got up with her hands in the hands of the husband. They walked out, they didn't speak to media, went straight to her car and left.
And that was it. And then you spoke to the Godfrey Dame,
yes,
who represented her in this particular case. What was his reaction?
Godfrey Dame says he's not surprised by the outcome of the case, but he still holds the view that this entire process is flawed. I asked him specifically that if the belief by him and the Chief Justice that this process is flawed, why would the Chief Justice not just save herself and resign, or perhaps step aside?
Instead of going through this process.
Going through the process that they view as a sham process of a sort. But the indication he gave was that it appears the Chief Justice is willing to fight this to the very end. Listen to Godfrey Dame.
Not surprising, because it really follows in the theme of what we've been witnessing. But yeah, I think that we move on. There are a lot of battles that we can fight. We think that the process is flawed, no doubt. I mean, heavily flawed, laden with all kinds of constitutional violations. And I'm quite surprised that the Supreme Court will be more or less acceding to the perpetration of such violations against the highest judicial office holder. It's not about Justice Tokunu, as I keep saying. It's not about Justice Tokunu at all. The issues are far-reaching. They actually impinge on matters which affect the independence of Ghana's judiciary, the security or tenure of judges and all. But if the Supreme Court, for whatever reason, that don't seem to take that view, well, so be it. I think that in future, the whole nation will get to know the consequences of this.
You said there are more battles to be fought. Are there specific measures you'll be taking going forward?
I'm not here to disclose to you my line of action or plans. But clearly, what we can say is that this is a procedure that should be deplored. There cannot be a situation where the Chief Justice cannot face an inquiry set up under Article 146 of the Constitution to determine some inquiries against, some petitions against her. And she's not had notice of the specific charges in respect of which the prima facie case has been made, the basis for such charges, and the reasons why she's supposed to go through the inquiry. I mean, this is a basic right that is available to every citizen of the country. It's not an account of her being a Chief Justice or her requesting for the grant of higher rights than as are due ordinary citizens. It's asking for basic constitutional rights. The notice of charges that she's standing trial or she's supposed to respond to, the basis for saying that's the case for her to answer. And indeed, this is a very significant point. It's a decision that resulted in her suspension. Are you saying that she cannot know the reason why she was suspended? She cannot know the specific charges on the basis of which the president said that she should go and stay at home and for another person to assume her office? I mean, this is very strange. It's something that is very much alien to every civilized legal system. But we'll see. We'll wait the reasons and then we'll deal with it.
Finally, from in your opinion, you have said that this process is deeply flawed. there are those who are calling for the Chief Justice to simply resign and save herself all the trouble from this. As a former Attorney General, if I were to ask your opinion as a lawyer for Madam Tokonu, what would you say to that?
Due process, rule of law, constitutionalism must prevail in Ghana. That is what we seek. It did not, on account of people putting pressure on the CJ to resign or do whatever, that we will take a decision. The most important thing is that there must be an upholding of the rule of law in Ghana. And we will continue to assert our rights. So the proper thing must be done. As far as I'm saying, the proper thing must be done. And she is a Chief Justice. She's been in office. She's been a judicial office holder for more than 25 years or so. She's been at the bar for almost 40 years. She knows what is due process. She knows what is constitutional rights. And I think that's what she's asking for. And how can it be correct that a judge who sat on 2 matters on which she also sat be called as a witness in a petition against her, and that same judge be made the chairman of the committee that is supposed to inquire into the petitions against the Chief Justice? Clearly, it's untenable. It's only in this country that, I don't know. And the question is, on what account can she be singled out for removal from office when indeed she did not sit even alone? She sat as part of a panel.
So Godfrey Yabwadame there is a former Attorney General, and now he is representing the suspended Chief Justice, Madam Gertrude Tokonu, in these matters. Kwaku, I'm wondering whether you got a response also from the Deputy Attorney General who represented the state in this matter.
Well, we did try to talk to him. He kept saying, I beg, I beg, I beg. He did not speak to the record on this matter.
There's media report that he tried to have a conversation with the suspended Chief Justice after the court event.
Yes, right from the top, you see that he beckoned the Chief Justice to try and exchange pleasantries. That attempt was rebuffed, and the Chief Justice did not give in kindly to that. From the top, you will not hear specifically what has been said. In fact, there are those who are down there who have sought to transcribe the argument, who said that the Chief Justice said, Mr. Sai, I will not be part of this. I'm fighting for not just myself, I'm fighting for the Constitution of the Republic. But we cannot independently confirm if those were the words she uttered from downstairs. But the suspended Chief Justice clearly did not take in kindly with the attempt for camaraderie between herself and the DAG who had come to court to argue against her case.
And then finally, the other matter relating to the Chief Justice's request before the court to allow this process to be telecast live. When would that also be heard? Okay,
so that goes into the main case. We expect that the processes will now be filed by both parties, and then on the basis of that, the court will issue some hearing notices. We do not expect that it will be heard at least until the end of June, when that matter may become ripe for hearing. But the interlocutory matters having been dealt with, injunctions and all that, that is the next thing to happen. But a specific date has not yet been set.
Kwaku Asante, thank you so much.